Human Services Reform Finance and Policy Committee. I'll just give you advice every time. Get a little free exercise, leave your computer upstairs and run up the stairs and back and get it and start 2 minutes late. So sorry about that. We have a lot to do today, and I wanted just to mention to people that our other day of the meetings are on Thursdays. We are attempting to make Thursdays work out as well as they can. If you recall, last Thursday we started at 2 and got done at 3 with all our bills. And so we're trying to schedule with not knowing if we'll be here at 1 o'clock or not. So we're going to try to make every effort to complete those hearings. We're not going to go past 3 by any means, just to not mess the rest of the committees up. So just to let you know. And so we, if we're in a position, we have a half hour, we'll try to see which bills have brought the most, people in that are unique to our committee. And respect that as best we can. With that being said, we have a bunch of bills today. Senator Mathews, are you out there?
Yes, I am, Mr. Chair.
And Senator Housley will move your bill to get it before us. So welcome to the committee. And we have quite a bit of testimony today. So if the testifiers can kind of keep their points to just a couple minutes, like 2. If you have something really critical to say, then we can go a little longer. But there's amendment.
Yes, thank you, Mr. Chair. There's a A1 author's amendment.
So Senator Housley moves to A1. Senator, would you care to please explain the amendment?
So the testimony will describe the amendment and the changes that they've been working out with all the stakeholders in. So I'd be happy to throw it off to the testifiers right now if you want.
No, that's fine. So that's good. And these are online, so I'd like to have them described, but it's too big of a description. So everybody understand the motion about the A1? Unmute, and all in favor say aye. Aye.
Aye.
Opposed? You're on a roll, Senator Mathews. Welcome to the committee, and tell us what you're up to.
Thank you, Mr. Chair. I'm virtually in 2 different places at once, a computer here and a computer here, trying to juggle today's schedule around. Amazing technology. But Senate File 984 is an effort to try to help with accessibility for transportation by those with personal care assistance programs. And this is something that advocates have been approaching me for a couple of years now to try to get movement on this. And I think that this has some real valid needs that this bill addresses to meet with some of them. So in the interest of time, I will kick it right off to Mr. Trevor Turner, who I believe is our first testifier, to go over the bill, the incorporations that they've worked out. The amendment was kind of a lengthier amendment to try to work out some details with the department. And I'll let them describe all of that, but I appreciate this committee's taking this bill, Mr. Chair.
Thank you, Mr. Turner. Welcome to the committee.
Thank you, Chair Abler, and thank you for members of the committee. First, I want to thank Senator Abler and Senator Utke and Senator Hoffman for speaking at our Disability Day at the Capitol event today. It really means a lot to the disability community to have you guys there and present and hearing our issues. I also want to thank Senator Mathews and Senator Nelson for authoring this bill. It's something that become relatively urgent during this pandemic, and so I'm glad we're able to have this hearing and discuss it. The Minnesota Council on Disability urges the committee to support Senate File 984 and not only improving community access to the Minnesotans with disabilities, but also expand transportation options in a time of great need during the COVID-19 pandemic. We've heard a lot of stories of Minnesotans missing vaccine opportunities because of the PCAs were not able to drive them in these appointments. And often opportunities to receive COVID-19 vaccines come at a moment's notice, which does not provide enough time for Minnesotans with disabilities to arrange transportation to vaccine sites on their own. So PCAs who see their clients regularly would be able to respond to these vaccine opportunities quickly and take their client to those sites. So Senate File 984 would provide another tool in the toolbox to fight the fight against the pandemic. Restricting PCA's ability to transport clients directly contradicts the principles set forth by the Minnesota Homestead Plan, adopted by the state of Minnesota in response to the legal settlement in 2011. The Olmstead Plan states that people with disabilities are entitled to live, learn, work, participate in their communities, and enjoy life in the most integrated setting possible. Allowing PCAs to the option of transporting their clients is key to ensuring that all people with disabilities can participate fully in their communities. Senate File 984 helps restore that access to their communities for Minnesotans with disabilities. The Minnesota Council on Disabilities supports this bill because any policy that helps Minnesotans with disability live lives that integrate them into their communities that they're familiar with is important. Minnesotans with disabilities trust their PCAs and develop strong relationships with them. So there's no better person to provide that transportation opportunity as part of their regular day-to-day activities. We also like to emphasize that this bill is not a mandate. It is strictly volunteer for both the client and the PCA. This bill simply gives clearance to those PCAs and their clients who have developed a trusted relationship with each other to drive together to a client's regular errands, medical appointments, community activities. So with that, I'll yield my time to other testifiers, but thank you, Chair Abler and members of the committee for your support in 984 by restoring that community access and PCA program. And I'm happy to take any questions after.
Thank you very much. And Mr. Olsen?
Good afternoon, members of the committee. My name is Cody Olsen. I'm the policy advisor for the Minnesota Council on Disability and the State Emergency Operations Center. And I've highlighted this issue to the Council on Disability and to the legislators here today. I just want to emphasize the importance of this bill, especially during the pandemic, to ensure that Minnesotans with disabilities have the flexibility that they need in order to access the tools and the resources that they need in their community to combat the pandemic. I'm simply here to answer questions if any legislators have any. I was MCD's policy advisor for the last 2 years and have worked very intimately on this bill. This is such an important issue to our community, and I really thank the committee for taking the time to hear this bill.
Oh, thank you very much. And I want to point out there's in the packet, there's comments from legal aid and a fellow named Ted Stamp who wrote a very eloquent note about why not, and then the Minnesota Consortium for Citizens with Disabilities. Questions from members? Oh, there is. Oh, Mr. Stamp, you're here in person. Okay. Or you're here to testify. Sorry, I didn't know. Mr. Stamp, welcome.
Yep.
Yeah.
Hi, good afternoon. Thank you. Would you like me to read it then? If you.
I would like you to give me a minute and a half. We have your written thing, so just tell us in a minute and a half why you think the bill is a good idea or a bad idea.
Oh, it's hard. I'll probably ramble longer than if I read it.
Well, what do you?
If I go
ahead.
off the cuff, if I'm off the cuff, I'll be worse than if I just read it. It's about 5 minutes to read, but if you have read it or would read it, I just submit it to you to read.
Well, let me ask you just some questions. How's that? So
Sure.
5 minutes would be difficult for us. So,
Okay.
so you're thinking this is something that's very important for us to do, correct?
Well, and if I think of the most important situations, I think of, situations already from my experience in that, I think of one where, like on a Saturday, one time I woke up with a kind of a searing pain in my abdomen. And I wasn't able to call because there's no dispatch on weekends here in Marshall. We have a good transit system, but we have no dispatch on weekends or evenings. And so I have a vehicle. I've got PCAs right here. And, usually these things happen. This happened to happen on a Saturday morning. But so I had to go to the ER. And we kind of just ended up, breaking the rule and just say, you got to drive me there because I can't get a taxi. And, if you call, you can leave a message, but you don't have any guarantee they're going to get back to you. But what I'm trying to say is that sometimes these things might happen late at night. And what are you going to do? The taxi's either not running or you're going to call and leave a message, not knowing if you get a call back. And you've got someone right there that can drive. You've got a vehicle that is yours to use. And the PCA statute saying, no, the PCA can't drive you because it's it's a violation.
Well, I'm glad they can help. Go ahead.
Yeah, that's probably the most important, other than, there's other things with just how busy the transit system currently is anyway. And, just sending people, I can send someone to the store for me, either in my vehicle or in another vehicle, but they might do some shopping and come back, bring home some stuff, and it might not be the stuff I want. I have to send them back to the store or whatever. And there's many. I make the points more concisely in the document I sent.
No, actually, your point is you've done extremely well to talk about one circumstance that's a really good illustrator of this. And I don't know why they would bring back so many lima beans for you. They're good for you. I don't want lima beans. So this could be the no lima beans bill. You just want to get what you want. So, you know, and I don't know, we're going crazy with Zoom. I don't know if you know, but the beauty of it is that you get to be a part of our hearing today. You never would have been able to get here with a PCA ride or otherwise. So thanks,
Sure.
Mr. Stamp. I really appreciate it.
You're welcome.
Yeah, so stand by. There may be a question. So,
Okay.
so now questions from members. Senator Benson.
Thank you, Mr. Chair. For Senator Mathews, I just want to clarify, is this the PCA's vehicle or the client's vehicle? Does this have any interactivity with automobile insurance? And then does the individual get reimbursed for the act of driving? So those are the beginning of my questions.
Senator Mathews.
Chair, Senator Benson, thank you so much. This would be the client's vehicle, and I may ask Mr. Turner to come clarify us. We've had discussions on those insurance questions, and I may ask Mr. Turner to come on and help succinctly summarize those for me.
Mr. Turner.
Thank you, Chair. Yes, I'm happy to do that. So they could use the client's vehicle or the PCA's vehicle. It's strictly voluntary. There is no reimbursement for mileage or gas or anything like that. It's only the PCA time, and it's strictly voluntary. So there's absolutely no requirement for them to drive. If they choose not to drive, they don't have to.
Senator
Thank
Benson.
you, Mr. Chair. And there's a couple of places where it designates that you're tracking traveling time. That's why the reimbursement question. And Mr. Chair, presume we're going to get a fiscal note with this at some point?
That's correct.
Okay.
And so,
that'll help clarify.
Oh, yeah, thank you. And so would it be, does the department, we just want to comment on how they see the costs working on this just philosophically, and then we're going to hear it again when we finally get the fiscal note, I suppose, or when we mark up our bill. But so does this burn up more PCA time so that it doesn't cost more for PCAs? Can the department, whoever is here, just comment briefly about that? Whoever you are, just Ms. Bailey, welcome. You popping up out of nowhere.
Hello. Yes, to answer your question, the cost of this bill will be primarily the cost of increased hours that we will pay in the service costs, and then potentially administrative costs related to changing the policy and making sure that all of the items related to, as Senator Benson mentioned, on insurance and policies that would be required to ensure that we roll this out correctly, that we would be able to do that as a department.
So, Ms. Bailey, you actually see an increase in PCA hours as a result of this, and is that necessary? All this, we just need to keep going on this, but for the advocates, sometimes the cost of a good idea makes the idea not happen. And so if there's a way that this could be part of the client's allocated PCA hours anyway, that would keep the cost down. So, Senator Mathews, you just want to keep that in the back of your mind.
Mr. Chair.
Senator Benson.
Mr. Chair, if I could, I would think if the PCA was running errands to get groceries anyway, or the person was eligible for an EMT transportation, that I'll be looking closely at the fiscal note. This is a pretty common sense idea if it can be done, safely with respect to the relationship and insurance, and safe driving. Then I think we should try to figure out how this goes forward. So I hope it'd be nice if it was a savings, because then it's a guaranteed go, right, Senator Abler?
Exactly, and so, Ms. Bailey, I hope that, since at least in Senator Benson's committee, you've begun to use dynamic fiscal notes, I hope you can see the substitutionary value of some of the NEMT rides by this, and you'll actually not have to pay for those. So any other questions, then you can just take that home with you, Ms. Bailey. Anything, other questions from members? Senator Mathews, I don't think I missed anybody. Senator Housley, are you unmuted? No? Okay.
Yeah, I'm unmuted.
Did you want to ask something?
No, sorry.
Okay. Well, welcome to the committee. Anyway, so Senator Mathews, last word, and then we'll lay it over.
Thank you, Mr. Chair. I think the advocates in conversations I have imagine wanting this to be incorporated into ours for the most part, with the exception of maybe the extreme stories that that we heard from Mr. Stamp about if there's an emergency at an off hour of the day. But we hope that those cases are very, very few and far between. But this is an option that we're trying to help get incorporated with them, and we'll keep your comments in mind as this moves forward. So thank you for your consideration.
Thanks, Senator Mathews, and to the advocates. You know, the lower the cost, the better the chances could happen. We hope it all does. So with that, the bill's laid over. Senator Bigham, Senate File 71, and there's a similar bill, Senator Utke's 891. We'll do them one at a time, though. So, Senator Bigham.
Thank you. First, with the chair of civil law being in here, and I'm the lead, I don't know who's watching the other committee at the moment, so that's fun.
Whoa. Senator Housley, let Senator Housley move Senate File 71 to get it before us, since she is unmuted. There you go.
Sorry, so moved.
Thank you, and thank you, Senator Housley. Mr. Chair, I appreciate you giving this bill a hearing. It's an important bill, and I'll be brief. Senate File 71 makes the Leech Lake Band of Ojibwe and the White Earth Band of Chippewa, along with our counties, whole for overpayments of reimbursements for substance abuse, disorder programming services that relates to federal noncompliance or eligibility due to direction given by the Department of Human Services. The sovereign nations and the counties should not be held responsible for the department's mistake. And if we don't fix this, this will be financially devastating to the two tribes and create hardships for the counties. Above that, making this right is the right thing to do, to be a good partner. So this legislation appropriates from the general fund to the DHS commissioner, a little over 8.8 million to the counties and nearly 29 million to the tribes, split between the two tribes. And I really will turn this over to the testifiers. I see, Mr. Chair, your good friend and mine, Anoka County Commissioner Scott Schulte. And then we have representatives of both the Leech Lake Band of Ojibwe and the White Earth Band of Chippewa. And we also have the department here to also answer questions and testify on the bill. With that, Mr. Chair, I am done.
Thank you. And I want to welcome the testifiers. And I noticed there's there's a pair of tribal representatives and a pair of county representatives. So as they go a couple minutes, if their testimony could inform your testimony, and you could say something a little different than what the person ahead of you said on your own cluster there, that'd be great. Anyway, Chairman Jackson, welcome to the committee.
Bonjour. Bonjour, Chairman Abler. Can you hear me fine?
We can hear you great. Welcome.
Great. I'll keep it within 2 minutes here. I kind of speak kind of slow, so I'll kind of try to speed it up here for you. But I just want to say, bonjour, Chairman Abler, members of the committee. Thank you for allowing me to speak at this hearing today. My name is Farron Jackson Sr., and I am the chairman of the Leech Lake Band of Ojibwe. I am here to express Leech Lake support for SF71. As sovereign tribes, we stand united. The Leech Lake Band's position from the onset has been that we will not repay the money because we are not at fault. That remains our position to this day. And the Office of the Legislative Auditor's report confirms that we are not at fault. We know that requiring the tribes to repay this money will not reach a meaningful resolution nor address the ongoing crisis our communities face. Seeking repayment in excess of $14 million from the Leech Lake Band will result in catastrophic cuts to our important services and programs needed by the most vulnerable members of our community. and will ultimately only serve to exacerbate the opiate epidemic in the long run. This bill would ensure that an error on the part of DHS does not negatively impact our most marginal and needed citizens. This is an urgent issue for the legislature, and it was derailed by the COVID pandemic during the 2020 session. The nonpartisan Office of the Legislative Auditor report in October 2019 confirmed that the overpayments were the result of a dysfunction at the Department of Human Services and that the ban was not at fault. The administrative law process is not providing relief. It's being dragged out until 2022, and it is extremely burdensome for the band, and the outcome remains uncertain. There is simply no way that the Leech Lake Band of Ojibwe can pay this money without creating significant harm to our communities. Miigwech.
You're welcome. Very good testimony and good job. Mr. Feinday, welcome to the committee. Nice to have you back.
Thank you, Chairman Abler and members of the committee. I here today to testify on behalf of White Earth Band and the White Earth Band support of Senate File 71. The reason we're here today is to correct an anomaly of state law. At the crux of the issue, the Minnesota Department of Human Services made a years-long and costly error in the billing reimbursement for programs vital to the efforts of sovereign tribal governments in combating the deadly and costly opioid epidemic that has been ravaging our communities for far too long. From the outset, there's been no dispute. The tribal governments committed no errors, save to rely on the advice from the Department of Human Services. DHS has claimed responsibility and admitted error. So why are we here today? Under current state law, specifically Minnesota Statute Section 256B.064, Subdivision 1CA, and Section 256B.0641, Subdivision 1-2, DHS can recover overpayments even when it is clear DHS is in error and not the provider. Importantly, these statutory sections apply to all Medicaid providers in the state, and current state law makes no room for exception or recognition for instances where sovereign tribal governments are the service providers. SF 71 would appropriate the money to cover DHS's error without requiring the tribal governments to subject themselves to state administrative and judicial processes. To be clear, the tribes have begun the administrative appeal process through the Office of Administrative Hearings as contemplated by statute, simply as one path forward to resolve this outstanding issue. However, as Chairman Jackson mentioned, our contested case hearing is not even scheduled until March of 2022. This matter has already been in process for over 18 months and has held the tribes in limbo regarding our programs and our ongoing plans to battle the opioid epidemic. With this issue unresolved, the tribes are required to report overtly threatened or pending litigation or an unasserted possible claim or assessment to our auditors, which has the potential to harm the tribes' stance with creditors and funders. This is why a legislative fix is both important and urgent. While SF 71 appropriates the funds that would cover DHS's error in this specific matter, it doesn't solve the larger and underlying issue of the statutory provisions mentioned above that allow DHS to recover from tribes even when DHS is in error. The White Earth Band asked the committee to approve SF 71, but to also consider language that would revise state statutes so we don't find ourselves in this same situation in the future. Thank you for your time today, and I'm happy to answer any questions. Miigwech.
Yeah, I think it's well said. Thank you. Mr. Schulte, Commissioner Schulte, welcome to the committee. Nice to see you.
Well, thank you, Chair Abler and members of the committee for allowing me to speak today. My name is Scott Schulte. I'm the chair of the Anoka County Board of Commissioners and the past president for the Association of Minnesota Counties, an association representing all of Minnesota's 87 counties. Today, I join you to speak in favor of the two bills in front of the committee, Senate File 891 and Senate File 71. Both appropriate funds to the Commissioner of Human Services to reimburse counties and tribes for funds and some costs incurred as a result of DHS billing errors. I'd like to thank Senators Utke and Bigham for authoring these two bills. These bills do address an issue that stems from 3 state-identified errors. The focus of the conversation today is a substance use disorder, IMD, billing issue, in which a state improperly billed the federal government for certain services that counties carry out and are now, in turn, asking for counties and tribes to pay back a portion of those funds owed to the federal government. What is clear and agreed to by all parties is that regardless of how these mistakes happened, counties and tribes had no way to anticipate or control these errors. In a state-supervised, county-administered system, such as Minnesota, counties rely on the state to implement and communicate federal regulations, provide billing systems and technologies, offer training, and oversee compliance with federal regulations. Counties should not be expected to be financially responsible for errors within these systems. In particular, because counties are not at fault regarding these errors and have no ability to plan or prepare for these unexpected costs. While DHS has been generous in communicating with counties and sympathetic in recognizing the inherent problem and fiscal impacts, the agency has informed counties and tribes that state statute requires them to seek repayment. As you can imagine, repayment gives counties 2 bad options: take funds from existing budget programs and/or reserves, which would potentially impact an array of services we provide to our clients, or increase our property tax levy to accommodate for the payback, which will negatively affect property taxpayers. Neither of these 2 options is an appropriate solution to a state-level billing error. That is why a majority of counties across the state have still not yet paid these DHS-issued bills, as we are hoping that the legislature will step forward to resolve this issue at the state level where the errors actually occurred. We appreciate that DHS has attempted to provide solutions to the immediate fiscal impact of these repayments, including several plans that would allow for repayment over the course of up to 5 years. We still believe the only appropriate solution is for the state to pay for the cost of these errors. Whether a county's bill is only several $1,000s or more than $2 million, these bills represent significant, unplanned, and impactful effects on county budgets and programs. During this pandemic, there is more pressure than ever on county property tax levies and reserves, as we seek to both hold down tax rates and direct our limited funding to services aimed at housing security, business assistance, and food support services. To ask our local property tax payers to shoulder even more of a burden during these times for something they were not responsible for does not seem right. We know that this session will present extremely limited opportunities for additional spending. We are hopeful that a rosier February forecast, combined with additional federal relief dollars, may assist you in your committee in identifying the resources necessary to solve this bipartisan and bicameral supported proposal. In closing, on behalf of my county, Anoka, and the Association of Minnesota Counties, we thank the authors and the committee for their time. We look forward to continuing to work with both parties, both chambers, and the governor's office to seek a permanent resolution to this issue. Thank you again, Mr. Chair.
Thank you very much. And Senator Bigham, Anoka County is a great place to raise your kids. So thank you, Commissioner. And so Ms. Mersch from St. Louis County, also a good place, a great place to raise your kids. So welcome to the committee.
Thank you, Mr. Chair, members of the committee. My name is Linnea Mersch, and I'm the Director of Public Health and Human Services for St. Louis County. I'm also testifying in favor of both bills, SF 71 and 891, on behalf of St. Louis County, as well as representing both the Minnesota Association of County Social Service Administrators, MACSA, and the Minnesota Inter-County Association. Thank you, Commissioner Schulte, for the overview of county fiscal challenges. I'd like to share a director's perspective of the difficult place this puts us in. The process by which counties are billed the state share of the substance use disorder treatment costs is quite complex. County action steps are at the beginning and the end of the process. We determine eligibility, authorize services, and pay the bill that is sent to us. DHS calculates the bill. DHS manages the various cost shares by setting and type and manages this ever-changing IMD determination with CMS. That status significantly impacts the county, federal, and state share of the individual bill. As has been shared, this error is not a billing issue, but an IMD determination issue. The state used inaccurate non-IMD determinations for 37 programs whose status changed, billing the federal government and counties an incorrect share. When my fiscal team sees a monthly bill, it only references this invoice is for the county's shares of claims paid to the Consolidated Chemical Dependency Treatment Fund. It has a monthly unit of 1 and a net amount identified. We process those kinds of bills for payment. So again, this isn't a billing issue, and it is an IMD determination issue. Based on the CMS review and findings, DHS corrected these errors, repaid the federal government, and now are required to recoup these dollars from counties. As stated by Commissioner Schulte, this represents a problem for counties because we don't have a role in the determination and no way of knowing there was an error. We paid our bills on time. We closed the books at the end of each fiscal year and had no knowledge of any outstanding fiscal liability. No funds were set aside for this kind of an error. For county directors to have to come up with funds during this current fiscal year, especially marked by ongoing pandemic, constrained budgets, new costs, higher needs, financially impacted communities, or considering a request to their county boards for levy support in 2022, when our own county boards are signaling little to no support for levy increases, is difficult, if not impossible. In closing, I just reviewed St. Louis County's opioid overdose data for 2020. We saw our highest number of opioid-related overdoses since we started tracking in 2013. Fatalities also increased, even though Narcan use continues to increase. St. Louis County, as many of you know, has been disproportionately impacted by the opioid crisis, and we continue to see the impact of drug and alcohol use and abuse on individuals and families. Our share of this $8.8 million to be recouped is disproportionate to our population, our tax base, and our budget. It is the third highest amount in the state because of qualifying individuals who received treatment that happened to be in the setting where an IMD determination had been made in error. As director, I need to advocate for investments that continue to change the tide in prevention, earlier intervention, and our proven strategies for improving substance use disorder. Thank you for your time, and I would be happy to answer any questions.
And thank you, Ms. Mersch. I appreciate that. And actually, it's a pretty good array of perspectives here. And so the commissioner is here as well. So Commissioner Harpstead, welcome to the committee wherever you are, and the floor is yours. There you are.
Thank you, Chair Abler, committee members. In 2019, payment issues were discovered in the Department of Human Services that added up to 0.1% of the department's total payments over the previous 6 years. We kicked off 3 simultaneous efforts to deal with that 0.1%. Hello?
We can still hear you.
Can you hear me?
Your screen is freezing up, but I can hear you.
Chair Abler, can you hear me?
We can hear you. Your screen is frozen, but we can hear you. So if you want to turn your video off and just talk, that would be an idea, or whatever you think.
Okay, you can hear my testimony?
Yes, Commissioner.
Okay, I'll just continue. We kicked off 3 simultaneous efforts to deal with that 0.1%. Operation Swiss Watch was a full Lean Six Sigma process improvement effort by our own Office of Continuous Improvement. And an outside consultant to put stronger process controls in place across the department. That report is due any day now. Not wanting to wait for such an in-depth report, we also kicked off Operation Stopgap, whose results were reported at the start of this session to the Senate HHS Policy and Finance Committee. We also formed a Commissioners Advisory Panel chaired by Bill George of Harvard and formerly Medtronic, and Penny Wheeler of Elida Health, including our 4 HHS committee chairs and others, to monitor and advise us on our ongoing progress. I'm pleased to report that we discovered no new payment issues in the department in 2020, not that there will never be another, with $17 billion flowing between federal and state government, 87 counties, and hundreds of providers every year. Back to the errors from 2019, we have since scoured all the claims associated with them, paid back the, can you hear me? Federal government payments and underbillings in these cases. Minnesota Statute 16D.02, passed by the legislature in 1994 and others cited by Mr. Feinday today, requires the department to recover carryover payments and or underbillings from the entities that received them, and they have been invoiced for them. Of course, the legislature has the authority to make an exception to statute to pay these funds, or to make an exception by ordering the commissioner not to recover the funds. Without that, we have limited avenues of administrative action we can take, including long-term payment plans to recover the funds. I will go on record once again this year to say that these were indeed two significant errors by the Department of Human Services. The tribal overpayments resulted from incorrect guidance from the department on how to deliver medication-assisted therapy that affected two of our tribal nations for over a decade, and reached a level that would be nearly impossible, if not impossible, for them to pay back. This question is currently also going through an administrative law hearing process. The county underbillings for IMD payments were billing errors over 5.5 years, not unlike errors that occur from time to time between state and counties that have been resolved before by long-term payment adjustments. We appreciate that these are a strain on our county partners, especially when repayments are not in current budgets, which is why we're at least able to offer repayment plans over the same period that the original underbillings occurred, starting with the next fiscal year. Offers is to make an exception to the statute. If not, we will proceed with the administrative options at our disposal. Thank you.
And thank you, Commissioner. Appreciate your testimony. Questions from members? I have one. Oh, I see. Senator Benson, you can go first.
Thank you, Mr. Chair. I just am frustrated that taxpayers are having to solve this problem. I appreciate the reform that Commissioner Harpstead has put in place. Do you remember when 16As and 16Cs were a big deal and they've all gone away now? I know the tracks need to be reimbursed. I know the counties need to be reimbursed, but it's still frustrating that the people who had the most ability to know a mistake was being made didn't do their job. And now we're getting the bill. We should hold the counties and the tribes harmless. But again, I hope in the Harpstead era, accountability becomes the mantra. But it was not, obviously, when these errors were made. So it was more of a speech than a question, Mr. Chair. Thank you for allowing me to speak.
Thank you, Senator Benson. And if I could, I'm not going to attempt to restate your comments, but what I think you were thinking and what you said partway is that appreciate the Commissioner Harpstead's work on making things work smoother there, and there's large evidence of that already, and thank you for those efforts. Other questions from members? I do have a question for Mr. Greenman, unless I don't think you know the answer, Commissioner, so we'll jump to Mr. Greenman. If you want to hop in, you can. How are these two accounts tracked in the forecast? So the 28 million and the 8, I'm told they're in the forecast somewhere as a collectible receivable thing. Mr. Greenman, how would they, if I was going to look for those in the forecast, where would I find them?
Mr. Chair, Dave Greenman, Budget Director with the Department of Human Services. You would find the tribal MAT issue or the repayment issue in the large forecast background documents in the Consolidated Chemical Dependency Treatment Fund. And what that will show is the forecast needs to reflect current law. So the forecast will reflect the state paying back the federal government and then a reimbursement coming in from tribal governments to repay the state for the tribal MAT issue. Similar thing with the IMD issue. It'll show the state paying back the federal government for the correct, or the, repaying the federal government, and then the tribe or the counties picking up their share of the cost in the forecast document. I can certainly point that out to you. It's
no, I don't need to. I don't really need to look at it. I'm just curious. I thought I'd just ask it that way so you could know how to answer my question, because I wanted to be clear, because sometimes I'm not clear, I'm told. So is that a payable recognized in fiscal 21, or is it recognized, since there's a ALJ in 22 coming, is that recognized as a 2022 I mean, how does that show?
Mr. Chair, it is recognized in fiscal year 21.
Okay, thank you. That's helpful to know. Other questions from members? Okay, I think we're going to move right into the next bill. So this is, Senator Bigham, did you want to say something? We're going to discuss the next bill now, but go ahead, you can actually close this out.
Just thank you. Yep, just thank you, Mr. Chair, and I'm going to head back to civil law unless you want me to hang on, but I don't disagree with Senator Benson's comments, nor with the tribal leaders' comments about making sure that we clear up the statute in holding, I say especially sovereign nations, but also counties when there's a mistake by the state, because as I'm sure Commissioner Schulte would agree with me, there's a few.
Thank you, and you might actually at least want to read the A1 amendment from Senator Utke's bill. You might like that one. So with that, the bill's laid over. Thank you, Commissioner, for your visiting us about that. Senator Utke, we're going to do this pretty briefly. It's the same, your bill, you have a delete all, which we can adopt, and then we have another testifier, but I think the big thing is going to be your A1 amendment, or A2 amendment, or A1, excuse me. So, Senator Utke, we'll take up Senate File 891, and do you just want to move your delete all, the A2?
Yes, thank you, Mr. Chair, and right, to get things started, I would like to move the A2 delete all amendment to Senate File 891.
And so for people watching at home, it's pretty much just makes the bill a little shorter. It says almost the same as Senate File 71. So everybody understand that motion? All in favor say aye.
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 Opposed? Senator Utke, to your bill.
And Mr. Chair, I would like to also offer the A1 amendment to bring the bill totally into a line, and then we'll talk about what the whole thing does or what we're doing with it.
And I think we should discuss the A1, because that's, just go ahead and describe what the A1 does.
The A1 amendment, and there was a little conversation about it in the previous bill, and there's one sentence added. It's under the recovery procedures, and I'll read that sentence. The commissioner shall not recover any overpayment that is caused by, affected by, or otherwise the result of an error by the department. And then right below that, the effective date, it's retroactive to June 30th, 2019. So it directly impacts what we're talking about here in these two bills and puts everything into play going forward.
Thank you. Senator Benson? Your hand
Mr.
up
Chair,
about this? Yeah,
I completely support the spirit of the amendment. I think there needs to be some work on who would determine what is an error, if it's in part, is there any shared responsibility? So great concept. Senator Utke, you and I can spitball some ideas what that might look like, but absolutely support the A1 amendment. Details can get worked out.
That's actually a very, very helpful observation. Not the observations aren't always helpful, Senator. Anybody other questions to the amendment? All in favor of the A1 say aye. Aye. Opposed? It's adopted. So Senator Utke, the bill really is the same bill pretty much as what we just talked about. And Ms. York is here to testify, or she's not?
Mr. Chair, you may want to have Mr. Albrecht or Mr. Housley talk about how the A2 amendment is different from Senate File 71.
Mr. Albrecht or Mr. Housley, I would like to be informed about how I was this wrong.
Mr. Chair and members, briefly, the A2 amendment sort of inverts the proposal from SF 71. And instead of a general fund appropriation of the amounts necessary to meet the overpayments that have been calculated, that's been converted into a direction to the Commissioner of Human Services to allocate those amounts apportioned among the general fund appropriations for the Human Service Department's central office operations. So it would be an internal allocation rather than a general fund appropriation.
Apologies, it's a considerable difference. The commissioner may want to come back and talk about that one, but I can tell you what her testimony is going to be like, hey, we haven't got that kind of money laying around. But all right, so, and the commissioner, if you don't want to come back and say that, you can. I'm not sure if you were aware of that. So other questions from members? Oh, and while she's thinking about coming back, Ms. York, did you want to testify?
Good afternoon, Senator Abler and committee members.
And actually, this is taking more time than we counted on. So if you can just kind of say something that's novel and maybe talk about how you like the idea about being forgiven, the whole idea. Go ahead, Ms. York.
Exactly. I was just going to say that I think Lenny Feinday did an excellent job this morning. White Nation would be in support of the changes in this amendment for Senate File 891. Miigwech, thank you.
Yeah, that was awesome. And you're just so good to have around. I hate to rush you like that.
Mr. Chair,
Senator Utke.
Thank you, Mr. Chair. I will add just one little bit of information for people that I had gotten this morning. And when we talk about these repayments or possible, who's paid, who hasn't, their counties have a small handful have made minor payments against these bills that they've received, varying between $200 and $1,000. So there's very little money that's come in. The tribal governments haven't paid any. So this full circle of money and reimbursements, it's pretty much all just still on paper. Okay. But there has been a little bit that's been paid that would have to be reimbursed, and that is part of the bill too.
Okay. Senator Wickland, and then we'll go to the commissioner.
Thank you, Mr. Chair. I guess I just wanted to say that, since we just added that amendment on, that changes it quite a bit. And I just wondered what the process is going to be. Are you going to bring both of these bills back for further discussion later on, or?
Well, we have two very different proposals in front of us. And so when we mark up our omnibus, I imagine we'll try to address this in some way. And I believe that discussion is very open at this point. So I don't have a plan yet, so that's the honest answer.
Okay. All right.
Commissioner, welcome back.
Thank you. I'm going to turn off my video just to be sure you can hear me. And wanted to start by saying, we don't have that kind of money laying around. So thank you, Senator Abler, for bringing that up, because that's true. And I know our advisory panel that's been monitoring our progress on your behalf for the last year would be pretty sure that taking this kind of money out of our administrative budget would all but guarantee that payment errors would continue to be made in the years ahead. That's all.
I appreciate that. And Mr. Greenman, thanks for coming back. And I know you have lots of things going on today. Mr. Greenman, let's just imagine that the A1 amendment is the only thing that leaves this committee, and we take away your authority to collect. What would that mean to the budget? The retroactive part in particular.
Mr. Chair, the cost of the repayment would be picked up within the appropriation for the forecasted program, and the cost then, to the extent that it exceeded what's currently appropriated to the department for the forecasted program, would the excess amount would show up as a forecast adjustment article in the legislation, forecast adjustment legislation before the legislature at some point, probably during the next legislative session.
So it would be, it's a cost to the state, obviously. The state would lose the receivable, and then the forecast would pick up the difference, because are those both forecasted programs?
Mr. Chair, yes, they are.
All right, well, that's helpful. Other questions from members? So Senator Utke, why don't you take the last word, and then we'll lay this over, and I'll just go, and then I'll let Senator Utke have the last word. And I know the department does not take this as a cavalier thing. I think they know that the counties and the tribes don't have that kind of money. And so we have to try to find a way to work our way around this. We don't want to crush the counties and the tribes either. And so we'll work on this, and I'm happy to have two capable authors like Senators Utke and Bigham on this. And so Senator Wickland, by the time we get to our markup, I hope there's some kind of resolution that we can live with that makes sense. So Senator Utke, you get the last word.
Thank you, Mr. Chair. And I'm going to wrap up with basically a question, but I would appreciate it. We can get the answer offline so we don't use up any more time here for the committee. But the fact is DHS has already paid back to CMS this amount of money. They've got it somewhere. Basically, if we could find out where did it come from, and I know that in the books a receivable is the asset, and that would be an asset going away, which would affect the forecast. But I'd like to dig into that a little bit further down the road. But for right now, I thank you for hearing this bill. I think it's something that's been extremely important. It's been hanging over the heads of our counties and the two tribal governments for the last year and a half or better, and we need to come up with a solution because as it's been heard here earlier and previous years, they actually questioned what was going on and were told everything was okay. Just keep doing that. So we just need to get a solution to this and get it wrapped up so that this liability goes away and they don't have to keep worrying about what is the state going to send us next. So thank you.
Thanks, and I think that you've gotten the attention of the state. Interested parties, both Senators Utke and Bigham. So thank you for that. With that, the bill is laid over. Senator Housley, let's take up Senate File 1013 first. I think that's going to be the shorter one, and then we can put all the rest of our time into the sober housing matter, if that's okay. So if you can change gears there. Senator Housley moves Senate File 1013. Welcome to the committee.
Thank you so much, Mr. Chair. All right, I have it here. Senate File 1013 is the Childcare Assistance and Childcare Provider Modification. This bill makes several changes to the CCAP program in Minnesota. As you may know, CCAP is funded with federal block grants called Childcare and Development Block Grants, CCDBG. The program provides federal funding to states for child care subsidies for low-income families with children under the age of 13. Additionally, CCDBG allows for flexibility to pair state and federal funds to improve the overall quality of child care available to families within existing state and local systems. The modifications to this bill address the CCAP payments and recovery of overpayments. The problem is that the statute doesn't match the current practice and policy, and the current statute includes unnecessary and outdated language. So this bill would update the CCAP statutes to promote simplification and consistent application of existing policy, which will support clarity, transparency, predictability for children, families, and child care providers. And the changes in this proposal will not change how the current authority is being applied. How does this proposal solve the problem? It aligns the statute to the current policy and other existing laws, and it cleans up the statute by repealing unnecessary language. The first section would require the Commissioner of DHS to recuperate an overpayment of less than $50 that was the result of fraud or theft. The second section is conforming change related to provisional CCAP payments prior to completing a background study. Section 3 specifies that payments withheld during an investigation are forfeited by the provider if they have been found to have committed fraud or have been terminated from the CCAP program. And Section 4 modifies absent days language by allowing a provider to be assessed an overpayment for an absent day. It is just a housekeeping and technical change CCAP policy, and there is no fiscal impact, Mr. Chair.
Thank you. The department has some thoughts. Ms. Posson, is it? Welcome to the committee.
Good afternoon. This is Lori Posehn, Chair Abler and members, and Senator Housley. Thank you for your lovely overview. And yes, these are all either things that are in statute or other sections of statute. As some of you may know, we share some statute with our OAG partners. And so everything that's payment related in here is tied to other things in law. So these are all clarifications. And that applies particularly to sections 1 and 3. And as section 2, Senator Housley mentioned, provisional payments have not been made. They haven't been made since 2016. And section 5, with the repealers, just wanted to assure people that we aren't repealing anything that's not in another area of statute. So otherwise, I'm available for questions.
And Senator Housley and Ms. Posteen, it looks like there is a change about if it's less than $50, you're not going to take them to court, but over that you will. Before you had that chance to go to court over $50, which seems like reasonable. So you get the $28 million, now you're talking a different number. So anyway, just back to the last bill. Questions from members? You must have been very persuasive. Look at all the hands there. Okay. Senator Housley, do you want to take it home?
No, thank you, Mr. Chair and members, for hearing the bill, and I hope we can get this so we can have a cleanup and move forward. So thank you.
And I'm told it's being laid over. So is that okay? Do you want to go to take it to the floor? Is that?
No, we can lay it over, Mr. Chair. It's fine.
We'll lay it over, just keep it cozy here. So with that, the bill's laid over. Senator Housley, there's a bill with a lot of interest. You have Senate File 873. So Senator Housley moves Senate File 873, and you have a delete all, and a lot of interest in this bill. So can you just point out if there's something salient about why there's a delete all?
Yes, Mr. Chair, I'd like to move the A2 amendment.
And perhaps you could explain it, if you don't mind, just what the differences are. No, not
Yeah.
line, just philosophically would be fine.
Yeah, the reason for the A2 amendment is to bring down the cost of conducting the study and to address some of the concerns of the sober home providers.
Very good. So that's any questions on the A2? All in favor say aye. Aye. Opposed? Senator Housley, the bill is in the order that you like it. And do you want to, why don't you do your opening comments, and then we'll move into an array of testifiers, please.
Yeah, I'll be short with my opening. A sober home is a dwelling unit occupied by more than 4 persons, all who are in recovery from some sort of chemical dependency. What this bill's the goal of this bill is, it's a oversight of sober home study and appropriation. We want to increase the access to sober homes, promote person-centered practices in sober homes, potential oversight of sober housing programs, and providing consumer protections for residents of sober homes. I'm going to I have a lot more, but I'm going to let the testifiers hash through some of that, and if I need to fill in the gaps later, I will.
Well, thank you. We'll hear the testifiers, and then there's a good number of comments in the written testimony that people will want to look at. I just have, so with that, Ms. Abb, we'll just take them down the list. And if you're particularly happy with this, the way it is, just kind of talk about that. I'm particularly interested in people that are concerned about some of the elements of it, so we can address those. So, Ms. Abderholden, welcome to the committee.
Thank you, Mr. Chairman. Members, Sue Abderholden, Executive Director of NAMI Minnesota. I think it's really important to read the language of the bill as amended. It really is about bringing people together to try to figure out, how do we increase access to sober homes? How can we promote person-centered planning? How can we provide oversight? And how can we provide consumer protections? Sober homes do have an important role to play in the SUD and mental health systems. And all we're trying to do is ensure some basic consumer protections. People who live in sober homes are not renters, they're not patients, so they have no rights under those sections of the law. 50% of people with a mental illness also have a substance use disorder, which is why people have called NAMI with complaints and concerns, and why we are interested in this issue. The complaints we've heard include homes being dirty, infested with rodents, use of drugs in the home, people being evicted late at night with nowhere to go, people losing their deposits when they leave due to the poor conditions, and more. The letter from the Ombudsman also confirms that there are problems. And I want to say, this is not just a Minnesota issue, this is a national one. The 2018 support bill signed by President Trump mandated the Secretary of Health and Human Services to develop best practices around sober homes. The National Council on Behavioral Health and the National Alliance for Recovery Residences found there are inconsistencies in quality because there are not state-enforced standards of protection. This report recommends that states adopt a common definition, establish a certification process, incentivize providers to adhere to national standards, and expand investment in technical assistance for recovery housing. SAMHSA also issued a report on best practices for sober homes and included recommendations for states to define sober homes and the services they offer, and advised states to adopt a process of certification to assure program quality. Good stories, which are many, sober homes are important, don't negate the fact that there are people who have had bad experiences. What we all want is safe, sober living homes so individuals can advance in their recovery. Thank you.
Thank you very much. And I think we'll just hold questions to the end. So members, if you want to just write your questions down. So Ms. Walling, welcome to the committee.
Mr. Chairman, thank you for having me, members of the committee. My name is Dr. Sherry Walling. I'm a clinical psychologist licensed in both Minnesota and California. And I wish I was coming before you as a professional, but today I'm actually here as a family member. I want to tell you a little bit about my brother's experience. So in February of 2017, I received a call from a hospital in Montana letting me know that my brother David was in the ICU after an almost deadly binge drinking incident. So I got on a plane and I sat by his side for 10 days as he fought to come back to life. When he was ready to leave the hospital, he had no family in Montana and nowhere to go. So I brought him back to Minnesota with me and helped him enroll in a treatment program. So professionally, I know that Minnesota leads the country in access to high quality care, especially for people who are working to recover from substance abuse and addiction. And my brother did very well in treatment. This was his first attempt at treatment after years of alcohol abuse. He did the work and he graduated. He went to live in a sober house. He got a job delivering Jimmy John's by bike and another job running the omelet station at what was at that time called Hotel Minneapolis. So he was putting his life back together. But unfortunately, the house was a tough place. The stove was broken, the washing machine was broken. He spent a lot of his time at my house doing laundry, helping out, playing with my kids. He didn't want to spend time there. He was really worried about theft. So he kept his cash and guitar with us. He also talked about people using while living in the house. And it was really tricky to try to tell any authority or get any help about that. Obviously, he's living with these people. There's just sort of limited resources for getting help with the people that you live with. So his philosophy was to keep his head down and earn enough money to get an apartment. Unfortunately, after a year of sobriety, Dave relapsed. He relapsed the day after our father died of cancer. So there was a lot going on for him. And he went down a dark tunnel, but then returned to treatment. And again, he did well, and he wanted to maintain the promise that he made to my dad about putting his life back together. So in treatment, he benefited from a safe place to grieve. He eventually graduated and went to another sober house. And this house was horrible right away. I don't completely know all of what happened to him, but he felt extremely unsafe. He didn't want to be there. After the first few days, he called me and asked if he could stay with me. The arrangement that my husband and I had when we moved him to Minnesota is that we wouldn't house him. We have 3 young children. We just didn't feel like we could handle another person. So I said no. He called my mom, he called the treatment facility he just graduated from. My mom called the treatment facility to ask for another placement. He was desperate, and eventually he took all the cash that he had and he brought a train ticket back to Montana. He got a job in a restaurant and thought he could start again, but it was way too much change too fast. There was no continuity of care outside of a prescription and no safe place to heal and to grieve and learn to live in a sober world. So my brother died by suicide on May 10th, 2019, and he was 30 years old. 34, sorry. I also really want you to hear that he died 3 weeks after graduating from treatment. So as a family member and a professional, this is not how this should go. We know that people are most vulnerable during transitions. They're most vulnerable to relapse, to suicide. And our experience with the sober home is that it wasn't safe and it wasn't accountable. My brother was terrified and he wasn't granted the dignity of a safe place to sleep. So my sense is that we're dumping some of our most vulnerable people, those who are clinging to whatever shreds of hope they can, into unregulated homes where bullies rule and basic dignities of physical and emotional safety are denied. I know that many people have positive experiences, and these are an incredibly important piece of the treatment safety net for people who are working towards sobriety, but they don't always do what they're supposed to do. So one of the biggest regrets of my life is that I didn't offer him safety in my home. I didn't quite understand how terrible it was. I trusted the system of care, and I shouldn't have. And it turns out there isn't a lot of safety in the safety net right now. So I'm here in support of SF 873 with the hopes that another family won't have the same experience. Thank you.
Yeah, thanks, Ms. Welling. That's just compelling, and I'm so sorry.
Thank you.
Okay. Thank you for coming. Mr. O'Brien, welcome to the committee.
Hi, good afternoon, Mr. Chair and members of the committee. Thank you for the opportunity to speak today. My name is Rory O'Brien. I am the chapter leader of Minneapolis Students for Sensible Drug Policy. We're the local ambassador chapter of the largest global youth-led human rights network dedicated to addressing the war on drugs through sensible policy change. I also studied addiction counseling in Minneapolis at Minneapolis College and do outreach with people who use drugs and people in recovery. Over the past 2 years, we have been interviewing and meeting with former sober housing residents and sober housing managers. In a brief summary, these were the primary concerns: the varying costs of deposits and monthly rent or program fees. From people's stories and online listings like MASH, deposits range from no deposit to $650. Rent range from $550 to $800 a month, with one report of homes charging up to $15,000 a month for additional clinical services, but no consistent oversight. Lack of options for people who use medications for opioid use disorder, like methadone and buprenorphine or Suboxone, and also some homes restricting all mood-altering substances, including psych medications. Since this was a common concern and complaint, we checked the popular treatment programs Sober Housing Partners list, and only 35% accept clients on methadone, resulting in a dangerous option of people having to choose between housing and being forced from life-saving medication. An especially high-risk situation during an ongoing overdose crisis, especially with Minnesota's longer and colder winter season. Medications for opioid use disorder, or MAT, like methadone and Suboxone, are gold standard and the only treatment proven to reduce overdose risk. In addition, rights of people on medications for opioid use disorder are protected by federal non-discrimination laws, including the Fair Housing Act. There were inconsistent rules on eviction policies and evictions taking place for minor violations. There is a clear lack of consistent guidelines in place for what was appropriate to evict residents over. Stories range from being evicted for a non-violent argument with another resident, to being in between treatment programs, to not completing their housing chores. This often left residents with no place to go and no resources provided from the homes. Deposits are often kept during evictions, leaving many with barely any money in their pockets, let alone affording another deposit for another home. At the time, their main concern was not reporting these incidents, and some weren't even aware how to do so, but to find new housing fast or face street homelessness, often while trying to juggle mandated treatment and probation. We do not want to lessen access to people who require sober housing, but expand it. Our organization is comprised of members in recovery, former sober housing residents, and addiction counseling and mental health interns. Based on our discussions and lived experience, we urge the legislature to consider this opportunity to study and develop an approach for regulations that will protect the rights of sober housing residents. We support this bill and believe it is needed to protect our most vulnerable populations and people with substance use disorders. Thank you.
Thank you, Ms. O'Brien. I really appreciate your comments, and we're listening, so thank you. Mr. Sheridan, welcome to the committee.
Thank you, Mr. Chairman. Good afternoon. My name is Dave Sheridan. I'm the Executive Director of the National Alliance for Recovery Residences, known as NAR. And I'd like to thank the committee for giving us time, all of us time today, to talk about this matter of mutual concern. My remarks are about 3 minutes. I timed them, so yeah, happy to answer questions at the end, but I'll try to keep this brief. NAR is best known for developing the national standards for operation. One of your former people testifying had mentioned the President's Commission and SAMHSA's guidelines for quality recovery housing, and we had a hand in both of those things. We've also developed a model for state support and oversight that has been adopted by several states. And it's become the dominant model for developing quality statewide recovery housing systems. And it looks to me like your bill is in substantial alignment with what we recommend. So together with the National Council for Behavioral Health, NAR developed a policy guide for state legislatures, state agencies, laying out the reasons for adopting this model. And that's available to your staff and your state agency on our website. I think your agency may have already reviewed it. What Minnesota really needs to do is work with the experts, which would be NAR, MASH, to implement the oversight and support framework outlined in the guide and really is the subject of your amended bill. Several states have engaged with us to do that. And they've gotten really good results, including most prominently Florida, which had pretty horrendous quality and abuse problems. It has some features in it that address some of the concerns you've heard today. For example, that referrals to recovery housing can't be made except to a currently certified home that has the kind of oversight that our framework contemplates. And we've got relationships with organizations like MASH now in 30 states, and many of them are formed in partnership with state legislatures and addiction agencies. And that partnership is one thing that's currently missing in Minnesota. We've got a national base of experience to help make this a success. We've also got working relationships with the U.S. Department of Health and Human Services, the White House Office of National Drug Control Policy, State Alcohol and Abuse Directors, a national organization, and several other agencies. We're really acknowledged as the expert in recovery housing and applaud what you're trying to do here with this legislation. There was some mention that was forwarded to me about a state study. And for this, we have a better suggestion. The federal legislation currently pending called the Excellence in Recovery Housing Act, sponsored by Representative Trone in Maryland, will, if it passes, will provide funding for a more comprehensive study than the one that you were looking to do. And it would include an assessment of the state's quality, capacity, access issues, and where good capacity is needed in the state. So it addresses the access issues as well as the quality issues. And so our recommendation would be to wait on a study to piggyback on this bill because it will provide funding to your state agency to conduct an even better study. I'm happy to answer any questions you have and also to put you in touch with experts on our team if you want to explore how to really make this work for you in Minnesota. Thank you.
Thank you. And Mr. Sheridan, are you local or are you a national person?
I'm national. I'm in Los Angeles.
All right. Thank you very much.
We work through MASH, your Minnesota Association of Sober Homes.
Well, thanks for visiting Minnesota. It's actually kind of nice weather today. Ms. Madigan, welcome to the committee.
Hi, good morning. I guess it's good afternoon.
Thank you, Chair and committee members. My name is Barb Madigan. I'm the chair of the Minnesota Association of Sober Homes. Over the decades, there's hundreds of people have been through sober homes in Minnesota. It's important for you to understand that sober homes do not provide treatment, medical or clinical services. They are democratically operated, mutually managed sober residences. They are homes where the residents mutually support one another as they experience life in recovery together. The Minnesota Association of Sober Homes, which we call MASH, was formed in 2007 to be the certifying body for sober living in the state of Minnesota. We currently represent 60 operators, which has 158 homes with over 1,600 beds through the state of Minnesota. We maintain a registry of all of our MASH-accredited certified homes. We conduct mandatory training, which goes over life safety, ethics, conflict resolution, naloxone training, co-occurring disorders, cultural sensitivity, and MAT guidelines. MASH conducts home inspections on all of its prospective members, biannual inspections to all the current members. It's been said that there's no place for people in sober living to make complaints. This is not true. MASH accepts and follows up on all complaints sent to them. We have a complaint division, and which are, it doesn't matter if they're a MASH home or not. We do not deny that there are legitimate complaints. There are. MASH is dedicated to ensure that all complaints are addressed in a timely and thorough manner. When there is a life safety complaint related to one of our member homes, MASH conducts an immediate, unannounced inspection to investigate the substance and particulars of the complaint. When the complaint is related to an ethical issue, the MASH Ethics Committee investigates the substance of the concern raised and provides guidance, training, and/or discipline to ensure that our members are at all times meeting the MASH ethical standards. It's true that MASH does not represent all sober houses in the state. However, as cities begin to mandate that all sober homes belong to and meet MASH's standards prior to receiving their reasonable accommodations, our membership has rapidly increased. Many treatment centers also require that all their referrals for sober living be made to houses that are MASH certified. MASH has been part of the National Alliance for Recovery Residents since their inception, and we have adopted the same standards that NAR has, as well as SAMHSA. We are and always are willing to be open to suggestions and growth to make our members' homes better. MASH supports a study where if the majority of its members that are on that committee have the experience and expertise in sober living field and operate under the NAR standards. It is our recommendation that MASH, the nationally recognized recovery residents certification organization in our state, be the certifying body for all sober living facilities, and that the state provide financial support to MASH to fulfill this obligation. MASH does not support any effort by the state to license or regulate sober homes in our state. The preservation of our sobriety requirement in all sober homes is of paramount importance to sober living community, and therefore MASH does not support any effort by the state to undermine the abstinence-based model that is vital to the safety of the sober living community. All MASH houses accept some sort of medically assisted treatment. 85% of our houses do accept Suboxone, and we support that the residents of Minnesota that want to live in sober homes have their choice of what type of house that they live in. So we've offered a bill that we would like to be considered that kind of puts in guidelines of what NAR does, what our national organization does, and what other states have done. So thank you so much.
So you have a bill?
Yeah, it isn't attached. We have an amended bill that we submitted. It is attached in our evidence.
Okay. Well, that's fine.
Okay.
So people, we'll talk about that, I guess.
Yes. Yep, I did send that over, yeah.
All right, we'll keep working through testifiers, and then we'll come back
Okay,
and
thank
chat
you.
about things. Mr. Huggins is, Brandon Huggins, welcome. welcome to the committee.
Thank you, Mr. Chair. My name is Brandon Huggins, and I was asked to speak on behalf of my own experience in sober living in Minnesota. Qualify myself a little bit.
Get a little closer to the mic.
Oh, yes.
We don't want to miss a word.
I can qualify myself a little bit. I started using and abusing drugs and alcohol at the age of 12. For 20 years, I was a drug addict and alcoholic. Had many ups and downs throughout my period of use and abuse. I was homeless for the last 3 years of my addiction here in Minneapolis. I racked up a lot of criminal charges and that kind of thing. Was court ordered to go to treatment. Completed the first treatment center. Had nowhere to go outside of the treatment center, so went back to the streets, rinse and repeat, back to more charges, more requirements by law. Entered into my second treatment center in 2018. Was required to follow recommendations. Recommendations were to go into a GRH housing, which is, as far as I am aware of, is controlled by the state or oversighted by the state. That was kind of what the lady's testimony before me was, unsafe, unhealthy, bed bugs, that kind of thing. Left that place, more charges, more treatment. Fast forward to my last treatment center in November 2020, November 21st of 2018. That's my sober date. I went to inpatient, got out, was recommended to find a sober house that was under the MASH umbrella. Being as I've used and abused all drugs and alcohol, Suboxone and methadone, I didn't want to be around. The list was small of houses that were complete abstinence-based houses. I found one that I stuck with and stayed there for 14 months. I saw the way the house deals with any kind of relapse within the house, and it's though it's few and far between, there is protocol that is put in place. We all sign a resident agreement when we move into the house. The rules are perfectly clear. The options are put in place if someone is found to be intoxicated. We're going to try and find you a detox center if you want to stay sober. If you're not willing to do that, we'll call your counselor or we'll call your emergency contact. We'll do everything we can to find the safe place to land. In the 14 months that I was in the sober housing, I never saw anyone just walk off or get kicked out onto the street. Being as we were all in the same boat, we have a sympathetic spot of this is a disease. We can't harm someone or put someone in harm's way because their disease got the best of them. But I also have witnessed the other people in the house, all the other residents are also affected to any use in the house. And we have to take care of those people, the family unit that is built around sober housing. So I know I'm probably running a little close on time. But yeah, I firmly believe that what MASH does, I've gone through their MASH manager training and I see what their end goal is: safe and sober living and the ability for addicts and alcoholics to have a safe environment, to become a family unit, become a functioning member of society, which I didn't know what that was. And it has afforded me, being able to show up to work on time, sober. Family members are back in my life and I'm back in their lives. I have loved ones and I have connections with other men and women in sobriety that we feed off of each other and give back to this community. So
thank you. Well, happy to hear your testimony, so blessings to you. We have one more testifier, and I want to inform our affiliates we're going to run a little bit over time. So Chris Edrington, welcome to the committee. Welcome to the committee. And,
Good afternoon. Thanks for having us.
Thanks for spending a couple of minutes with us.
My name's Chris Edrington, and I'm an operator of a little over 100 beds in sober living in both Minnesota and Colorado. I'm a founding board member of MASH, the Minnesota Association of Sober Homes, as well as NAR, National Alliance of Recovery Residences. You saw Dave Sheridan, who's our executive director. I'd like to basically give all the senators and everybody who's listening on this committee an overview of we have state and national oversight of sober living homes. Recovery residence, as it's said in NAR, is the umbrella term for all kinds of different sober houses. There is a lot of stuff in place for oversight. We just need our own funding to do it right. That being said, when you hear the complaints about people being kicked out at 2 a.m. when it's 10 below and people losing their $500 deposits, these are anecdotal stories. Things do happen. I'm the one that answers the complaint line at MASH, and I settle most of these. There is not a giant, huge, enormous problem going on that has no oversight whatsoever. There's a lot of really thoughtful people involved in watching over the sober houses. And I'd kind of like to shift gears here a little bit and make sure, help you guys to understand that the way that a sober house operates internally, how it functions, why is it beneficial? When you go, if we all went and took a poll from a bunch of sober people 5 years into sobriety and said, tell me the most important thing about your early recovery, 90% of them would tell you the other people they met in recovery and the modeling and the camaraderie and the understanding and the living a normal life in recovery is what mattered to them. In the sober house, it's very much like a family. It's not a facility. It's not a facility like, for example, Hazelden. The continuum of care from a primary treatment center like Hazelden is the clinical aspect of acute care. And as you progress in your recovery, you need less and less clinical acute care services. By the time you're in a sober house, it's a social model atmosphere. So if we overdo the oversight, there's a fear that we could sort of muck that up a little bit. So I want you to understand that when inside the sober house, day in, day out, what we do, and one of the reasons we have more than four.
Just 1 minute, if you could just kind of.
Why we have more than 4 unrelated people is we need critical mass. You need to come home and have people there who are there to support you, right? So MASH and NAR have infrastructure in place to help this model grow. Oversight from any entity, we welcome the discussion about it, but I want to help everybody to understand that we want to preserve that milieu, that energy, that sort of dynamic that goes on within the family organization of a sober house, and that it is not a clinical facility. It operates very much like a family, and that's where the support comes from.
Thanks. Can you tell me how many sober house, there's 60 operators in MASH with 160 sites. How many others are there that are not part of MASH? Do you have any idea?
It's hard to say. I've been here 20 years.
Just a ballpark.
I would say how many more operators?
Yeah.
Or how many more houses?
Pick.
I would say probably another 100.
All right.
Probably somewhere between maybe 30 and 100 more houses out there that we don't know.
And just let me help the operators who are here speaking. You have, I think there's some very well-run places that you represent, the people that have chosen to come under your umbrella, and I think there's some really bad ones. I worked on this for 18 years. I had a way back when, I don't remember what year it was, when I was a young representative, had a sober house study, and I don't remember what happened with that. Anoka had a big blow up about badly run sober houses, and nobody wanted to go near anything. It affected their ability to even care about homeless people, just because it was such a bad experience. You had operators packing 8 people into a fourplex and getting tons of money, and it was horrible. And so just to help you understand what I see as a policymaker, we don't want to ruin the good things, but when there's people that are not doing what you are, we want to get them up to your level. And so if there is regulation in Minnesota and there's national standards or whatever, we don't need a national standard. We need a Minnesota thing, which would be fine. And as this study goes forward, and it's going to, and I'm going to be enthusiastic to see what happens next session when we come back with recommendations that I'm going to help pass, just so you know. write the standards to reflect what your people do now. So the well-run places will have nothing change, not to change abstinence work, not to change the family thing, but to create a level that the operators you would want to go away anyway would find it to be untenable and go find something else to do. Right. And not harm people. So I hear what you said, but help us establish the threshold. It doesn't have to be excellence, but it has to be safe and all that. So
MASH can welcome in all those non-MASH members with the proper funding to be able to build the infrastructure out to manage them. We're a volunteer board.
We have ways to get money. It's called license fees. Yeah. So be careful. You're not going to get a check from us. I'll just tell you that. So anyway, questions from members. Senator Hoffman.
Thank you, Mr. Chair. I don't know if you have any more testifiers or you want to.
That's all the testimony. Now is the question time.
So a couple of things that really come to mind. This really is directing the commissioner to look at program recommendations. If I'm understanding the A2 amendment, which we all adopted, this is getting a group of individuals to give recommendations to the commissioner. Am I not understanding that right, Mr. Chair?
That's right, Senator Hoffman.
So, and I see that a lot of times when we look at this, and you started to, as people were testifying, and Dr. Walling, the story of your brother immediately hit. There are two families that are immediate to me and my family that both their sons finished their 30 days and went, and within 2 days they had started using again and died. My own sister-in-law, my wife, last night when we were talking about this, went through multiple programs, right? And there was really no assurance safety net follow-up for her, and she's no longer with us. And it just breaks my heart beyond that. A lot of times there can be some good oversight in this, and I'm looking for the recommendations. Because in recovery, you're right, you're only as good as the people that are surrounding yourself that are around you, right? And it's your executive board of directors. But what really bothers me the most in this, and I thought I heard Mr. Chair Sue Abderholden say 50% mental health. Where the heck is the conversation about that interrelation of issues that are here? And it goes back to what Bishop Harding Smith told me. You know, John, if you could get a handle on mental health and get a handle on substance abuse, you could fix homelessness. And you know what? I think he's right. But if this system is so fragmented, right, because you asked a question about how many other homes are out there, and we don't know, right? We probably know someplace, but wouldn't it make sense if we truly care about person-centered, like is in here, that we want to be increasing access to, culturally responsive, that we would have some kind of baseline? And so what I think you're getting to here, Mr. Chair, is, and what Senator Housley, and thank you, I want to be on this bill, Senator Housley. I hope I can get on it because I think this is an important bill. It really drives that next level of communication and conversation, and I think it's about time we do that, because I'm not going to say anything bad about the Minnesota model, but the Minnesota model has been overused forever, and it's not that successful, Mr. Chair. And so, and yep, I said it publicly. We have the highest per capita of substance abuse counselors per person than any other state in the nation, and yet our success rate is 30%. And we personally know people that have died that because they weren't dealing with the holistic piece. I like where this is going, Mr. Chair. I absolutely do. So with that, I just wanted to say I'm looking at this as saying bring the recommendations to the Department of Human Services. This is the direction we need to go.
Other questions from members? I have some questions. I just want to be fair to everybody else. It was a very good statement. Thank you. So is someone from the department here that can answer? Ms. Bailey, is this your turf? or whoever else. I'm wondering who pays for this. Do we pay GRA, what do you call it, housing supports for this? Is it a county thing? Who from the department can tell me that? Mr. Burdick? Okay. He knows everything. Yeah. Welcome to the committee. You're muted.
The phrase of 2021. Thank you, Mr. Chair. Matt Burdick with the Department of Human Services. Sorry, Mr. Chair, had some technology issues there. So to your question about how these are paid for, I think it really depends on the type of setting. Certainly some are using the Housing Support Program, or formerly known as GRH. Some, we understand, are private pay, but it really does kind of run the spectrum of different types of settings. I think that's one of the intents behind this bill, is to try to get our arms around the universe of what all of these encompass.
Thank you. And I'll express an opinion. It seems if the county or the state is paying, that we have an interest in quality. And if it's all private, then, good luck. You can go do what you want with your own money. But I just don't want any more stories like Ms. Walling told us. And I think when she asked the question, that she thought it would be all right because somebody was watching, and I think it is my job. And I think it's this committee's job, and Mr. Burdick, I think it's your department's job, and Senator Bigham, and to the counties, I think it's your job, and to the cities, I think it's your job. And everybody's business becomes nobody's business, and I think we've got a gap here in our system, and I think we have some impressive people that have come before us on all sides of this. I think the solution, Senator Housley, lies in the testifiers you heard today and the people proximate to that. I don't think we need heavy-handed regulation, but we need to make it clear who's in charge. And if people may be part of it, and so you're going to work with the commissioner and so on, but there needs to be a sober person's Bill of Rights or something that they could expect certain things to be true. That's just my random thoughts. I have many more thoughts, which I will not go into. Other questions from members, and then actually I have just a question for the department. Is there going to be a cost to this? Do you know that? We'll ask a fiscal note, but Mr. Burdick, do you know offhand?
Thank you, Mr. Chair. Yes, there is a small cost to this. We did a fiscal note on the bill and the other body. I believe the net cost of that was around $60,000 for us to bring in a consultant to help us organize the conversations and do some research about what other states are doing.
Well, thanks. And I don't always like consultants, and I don't like paying 50 or 60 grand, but I think this is some of the best places we could put that kind of money. No, I just, anyways, Senator Housley, would you help me out here? Go ahead.
Thank you, Mr. Chair. It's a really, really important issue, and I think $60,000 for a study is a drop in the bucket for how many lives it will affect and how many lives it could save. It's extremely, extremely important, and I want to thank you for the support that we've gotten here in the committee, and to the testifiers for their stories. I'm very sorry about your brother, Sherry. But yes, Mr. Chair, it's a good bill, and it is our responsibility. It is our responsibility to make sure that there is some oversight, and a study is just a small step in the right direction. So thank you.
Okay, well, very good. So I think I'm going to quit there while I can still talk. Because I just have to say I'm grieved, and I'm angry, and I'm challenged. And I think there's no one better suited to work on this than Senator Housley and Senator Hoffman and Senator Draheim on the bill, and our good department who really wants to get after this. And I just tell you as chair, I'm committed to something coming out of this for whatever part I have. And it is time to get rid of the people that are just bringing to line the individuals that embarrass, smash, and NARM, if that's the right acronyms.
Yeah.
And so if you can encourage I'm going to call them worthy providers to be a part of this system in a constructive way and see what you do that's universally a good idea and make that the standard. And otherwise, they're not getting any money from me. And I think that'll get their attention. They can do private pay all they want, and people can vote with their feet. So
We're holding our members to a strict set of standards, which is growing. And
no, I appreciate it, but it's not your members that are probably the problem. Right. So I just don't want to hear from I just don't want any more sisters to show up here. Anyway, with that, thank you. It's been an excellent day.
Thank you.
We're adjourned.